All right, go.
All right. Good morning. It is October 27th at about 10 o'clock. Welcome to the third meeting of the House Cannabis Legislation or Legalization Work Group. It's a virtual work group meeting, so please be patient if we run into any technological or streaming issues. Before we begin, I'll remind the work group members that the briefing is being streamed on the Maryland General Assembly's YouTube channel. Work group members are going to be muted through the briefing. If you have a question after our three presentations, we'll be stopping after each of the three presentations. Please use the raise your hand function in your Zoom window. After I recognize you to ask a question, please wait a moment while Dylan unmutes your screen. Today, we'll receive a briefing about the impacts on the criminal justice system as it relates to the legalization of cannabis. As discussed in our first meeting, this group is tasked with addressing the expungement of previous convictions for cannabis and determining the appropriate changes to existing criminal laws that are related to cannabis. We also must review existing criminal and traffic laws and laws associated with paraphernalia and cannabis accessories. Ultimately, we must construct programs to compensate communities impacted by over-incarceration by cannabis included and related crimes. To help us understand the steps we'll need to take here at home as we consider the legalization of cannabis across Maryland, we'll hear from three panels of guests. And first, we'll hear from Maryland's District Court Judge, Chief Judge John Morrissey, and the Executive Director of District Court Operations, Rose Day, from the Maryland Judiciary. Chief Judge Morrissey and Ms. Day will provide an overview of the process relating to shielding of records and expungement in Maryland. After this panel, we'll open the floor to questions and answers. And then at 10:30, the judges will have to have another appointment. They're going to have to go. Then second, we'll hear from panelists from the Department of Public Safety and Correctional Services. We'll hear from the department's Chief Information Officers, Stanley Lofton, and the Secretary's Chief of Staff, Rachel Sessa, about the impacts associated with the potential legalization of cannabis. Lastly, we'll hear from Michael Hartman, a research analyst who works in the specific area of criminal justice reform at the National Conference of State Legislators, or NCSL. He'll provide a global overview of the criminal justice impacts as seen across the nation as other states have legalized cannabis. After the second and final panels, as I mentioned, we'll open the floor to questions every step of the way. And during that time, during the third panel, we'll be joined by Carmen Hansen, the Associate Director on Health Programs at NCSL, who will be on hand to assist with answering any questions. So we will go ahead and get underway because we're on a little bit of a time crunch. And Chief Judge Morrissey and Ms. Day, if you'd like to begin.
Good morning, Chairman, and thank you for giving us the opportunity, and to members of this work group. My name, for the record, is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. With me, I have Rose Day, who's the Executive Director of Operations, and the Operations Department is specifically designed to support the field with all policies and procedures, best practices, and business processes that we run out in the clerk's offices. So they would be the ones that would actually be doing the heavy lifting on these. If you could go to the next slide, please. I thought I'd start by just giving a couple definitions to make sure we were all talking in the same language. And as a primary matter, I think a lot of you know this, but I just wanted to reiterate that, you know, the judiciary views expungements as a matter of policy decisions for the legislature, and we defer to you as to how we do this. We're not pro or against any type of expungements or shielding. It really comes down to whether we have the technological capability to implement what you all want to do. And if I did, I would give it to you as soon as I possibly could. I hope you all understand that. So expungement is, by definition, is a removal of any information referring to the case from not just the judiciary and our own internal systems, either our case management system or case search, but also from all of the people that have touched that file. So it can affect, and I have a slide later on of all the different people it can affect. The result is that that case never existed. You can't find it anymore. It's gone. It's not viewable by anyone at any time. For shielding, records can be shielded, either full records can be shielded or parts of records can be shielded. Documents, for examples, the address of a victim can be shielded, so it can't be seen publicly. The clerks would still have the ability to see it, but no one outside the court would be able to see it. And there are some exceptions to that through legislation where you all have decided, for example, the Second Chance Act, where certain law enforcement agencies can view those things. You can use shielding in what you've done, and I'll go over a couple of the more recent laws that you all have passed that really speak to shielding and what that means. But that's basically what it is that it's blocked from public view. And then sealing is an entirely different concept. It's where a judge would order the record closed from public inspection, and it would only be available based on that judge and that judge's order to release those. If you could go to the next slide. Just to let you know, we've over the time how we've kept our records. So you can kind of see from this slide that in the 70s, everything was still in paper form, and we have records going back even before the 70s in paper form. Some are stored at the courthouses, some are at archives. We started to move to electronic data, not the actual documents in data, but a case management system where we would input information into a case management system. That kept extending through the 90s. In the 2000s, we had multiple case management systems. Each court kind of developed their own. And then starting in 2014, we have MDEC, and that's designed to have one case management system for the entire judiciary. And as you mentioned before we went live, Chairman, we went live in Montgomery County. That's the 22nd of 24 counties to have this. We're next to Prince George's and then on to Baltimore City. And I'm looking forward to that day, as you can imagine. If you could go to the next slide, please. The contents of a record can mean a lot of different things, and there's the physical electronic content, and then there's the narrative content. So there's electronic data. Now with MDEC, there's electronic documents, but there's also paper exhibits and paper documents. And then the one that kind of everyone forgets about is that everything that we do is recorded in court, and we have all those audio recordings that we store and make available to the public. On the narrative content side, each case may have multiple charges. Each charge may have a separate narrative about what actually occurred in that, and that's just free form writing. Some of it's typed, some of it's handwritten. And again, the audio recordings may reference, kind of when you're in court, they all blend together, and you can move very quickly from one count to the next count to the following count. Partially redacting the physical or electronic narrative content is a manual process, and I'll get into a little bit more about that in just a moment. If you could go to the next slide, please. Starting really, there were some things prior to 2017 that you all did with respect to expungement, but really the biggest one was the passage of the Justice Reinvestment Act that became effective in October of 2017. And that added a list of crimes. Not prior to this, really, there had been no convictions that were able to be expunged. With the advent of JRA, now there's over 100 crimes. There's actually more than that can be expunged, even if there's a conviction. There's waiting periods on that, 10 years for some, 15 for the others. But if you go to CrimPro 10110, you can find the list of all those. And they've actually been updated since 2017 and expanded. If you could go to the next change, particularly of interest to this committee would be what took effect on March 14th of 2021. And that prohibited our case search system, our public-facing docket entry system, to reference in any way a criminal case in which a charge of possession of marijuana under 5601 is the only charge in the case, and that was disposed of prior to October 1, 2014. And that's in effect now, so you can't see those cases on case search. You still can see them if you come to the courthouse. And I think CJIS, when they present the Department of Public Safety, will talk about the issues that they're having with respect to that, because that is still, when we transfer the criminal record over to CJIS, this is only pertaining to case search, so it doesn't affect the record that we send over to CJIS. If you could go to the next slide, please. House Bill 1336 also became effective on March 14th of 2021. It expanded the justice reinvestment expungement to include fourth-degree burglary, and it prohibited the case search from showing any charge that had a null, an acquittal, a dismissal, a favorable outcome in the court. And it also, I believe, it established a partial expungement work group that I'm going to present to next week. And then next slide. Finally, Senate Bill 201 that became effective at the beginning of this last month. It also spoke to marijuana and must appear, and it's what people have been referring to as automatic expungement. And I'll talk about that a little bit later, but what it says is, starting October 1 of 2021, any case that occurs after that date, if there are entirely favorable outcomes, then the person doesn't have to do anything. 3 years later, it will be expunged from their record. They still have the ability during that 3 years, because if it's a favorable outcome, they can still request it immediately. They can walk right out. And in fact, we advise individuals to walk right out to the clerk's office, get the paperwork that they need to do the expungement. They can file it right there that same day. What it does is it eliminates the need to file a general release and waiver, because 3 years have lapsed. If they want to do it prior to that 3 years, they have to file that. We created a new form so that the expungement and the general release and waiver could be on one form to make it a little easier for our users. If you could go to the next slide, please. There's another slide, unfortunately, that's blocked that speaks to specific marijuana charges, and I'll try to get that to you. I don't know why it's blocked, but I can see it's blocked. There's over 52 identifiable codes related specifically to marijuana that we use in the court in our case management systems. And they kind of range from possession of marijuana to obtaining marijuana by an altered prescription. Prior to October 1st of 2016, possession offenses were not identified by weight of marijuana. So we have no idea by charges as to whether it included, an ounce or a pound or whatever it may be prior to 2016. And then even in 2016, we only distinguished between greater or less than 10 grams of marijuana, because less than 10 grams is a civil offense and no longer a criminal offense. There's about 306 additional offenses pertaining to controlled dangerous substances. A lot of times they're charged, I'm sure, Chairman, as a state's attorney, that a lot of the charges start out with a possession of a controlled dangerous substance, and it doesn't reference whether it's marijuana or LSD or heroin. That's just the charge, and that's the way we keep track of these records. Now I'm on to the current slide, and this is kind of an overview of the expungement process. This would be the non-automatic expungement process, where a petition would be filed by an individual. We would have to serve that petition on the state's attorney's office. The state's attorney is given 30 days to answer the petition or object. If they object, we have to set it in by law for a hearing, and then we'll conduct that hearing and either grant or deny the hearing. And then we have to send that order out to anyone that's touched the case, and then we have to keep that open until such time as we receive compliance back from the justice unit that we've ordered to expunge. If you could go to the next slide, please. Typically, the petition to answer, as I mentioned, they have 30 days to respond to that, and then they have another minimum of 14 days to object to the hearing. The order of compliance, we usually hold open for 60 days, and then the minimum processing time from start to finish is anywhere from 60 to 90 days. And it can kind of vary how much time each clerk spends on the case, depending on how complicated the case was. If it's a district court case, we're going to be able to do it much quicker than a circuit court case, because there's more people typically that touch the circuit court case. If you could go to the next slide. Compliance is one of the changes that was made with the bill that made it 3 years to an automatic expungement. In that bill, we don't have to wait for a response back from the justice partners in a compliance mode. We send out, the idea is to send it out 60 days before the end of the 3 years, saying you have to expunge your records. But we don't have to wait under that particular bill for the our justice partners to respond back to us to say that they've done it. It's on them to do it. If an individual finds out that someone didn't expunge the record when they should have, they have the ability to file a motion to enforce with the court, and then we would issue an order and direct them, and the individuals could be held in contempt if they don't do what the court orders. So you can kind of see that there can be many people that touch a particular file. CJIS, any number of police agencies that were involved, the jail, state's attorneys, if we order community service or probation, the drunk driving monitor program, Department of Social Services, commissioners, controller, if the county's involved, the county attorney, our records warehouse, pretrial services, and it can even be to other courts. For example, if it's moved between the district and the circuit, we have to notify each other of those expungement of records. If you could go to the next slide, please. This is where I wanted to talk about expungement automation and make sure that this committee understands the difference when we use the terms. So automatic expungement can mean a couple different things. It can refer to the process for applying for expungement, similar to what I just talked about in Senate Bill 201. There's no need for the individual to file an application or petition. We identify it right after they leave court, we note it, and then the computer system at 60 days prior to the 3 years will send out notices to all the applicable people. It still takes some clerk involvement because they have to identify who was actually touched the file in this case. But that's what a lot of people refer to as automatic. There's no petition filed by the individual that's seeking the expungement. And that's distinguished from automatic expungement, which is a theory that you could press a button in the case management system and the file or the partial file would disappear and would be expunged. And that's the difficult part of what we have to do. And there is no button that we can push that would create that. It's still going to be a manual process to some extent. And if you could go to the next slide. Where a charge, in this case of marijuana, is part of a case with multiple charges, what we can do right now, and what we've been able to do to block in case search, and we've heard you over the years, and this is an advance in the development of what we could do from case search 2 years ago, is that we can now remove the charge that's subject to this in a multiple charge case and block it from case search. But there's still an indication that there's a charge removed. We can't mess with the numbering system because that's the way that CJIS tracks it. There's also difficulties with the hearings where we would have to go in and listen to the hearings and remove those that just reference the partially deleted charges. And then the narrative statement, the statement of probable cause or the statement of charges can refer to, let's say for our examples, marijuana, it could refer to it as marijuana, it could refer to it as a green leafy substance, it could refer to it as a controlled dangerous substance, it could be handwritten or typed in. We are exploring redaction software with IA, with the artificial intelligence, AI, I mean. However, what we've seen from some of the views that we've looked at of other people using this is that technology is still not 100%, and that it still requires human overview of it and oversight of it to make sure that we're catching what we need to catch. So, Chairman, that's kind of an overview of where we are with expungement. We are at the point where we have done everything that we can do technologically, and that it's going to require a manual intervention for anything else that's required. And I'd be happy to, I'd invite Rose to add anything that she wanted on this, or just open it up for questions for you all.
Good morning. If I could add a few things. Good morning, Chairman Clippinger and committee members. One of the things that Judge Morrissey talked about was the automation of expungement processing. And the one point that I'd like to add to that is that, in this day and age, we're really in a data-driven society. And we receive a large number of inquiries for data, especially case-specific data. And so we have to be incredibly careful about, providing that data to outside people, and make sure that expunged information is not included in that. And it can be incredibly difficult in going through a case file to look at things like service information if a defendant was served in a jurisdiction outside of where the case originated. That then adds additional compliance agencies to the expungement. So we would have additional law enforcement service agencies, additional jail agencies, all sorts of things. So just want to, make it clear that when we talk about looking at these case files and what the manual piece of it is, the impact of or the idea of just pressing a button could have serious implications on a person down the road if we have not identified all of those compliance partners.
And then just one other thing to add to Rose's statement is, I'll leave it at that, and I'll just open it up for any questions right now. I'd be happy to answer any questions.
All right, we have about 6 minutes here, it looks like. So we're going to start with Delegate Moon. If other people have questions, go ahead and raise your hand using the raise your hand feature. Delegate Moon.
Thank you, Mr. Chair. And thank you, Judge Morrissey. We've had a few rounds of trying to get this done, so I appreciate your presentation. And I'll just say for the benefit of the other members that in my attempts to understand this area of law, other states do run around bragging about their automatic expungement policies. And when I look at what they've done, if you peek behind the curtain, it often is actually automatic sealing or automatic case search removal or something other than the full-blown record obliteration that the judge is talking about here. So I hope everybody gets that. So Judge, here's my question. I don't want to make you go through the whole thing, but just so that the committee here understands what's possible with what you can currently do and what you may soon be able to do, is it fair to say that if we go down the road of taking those cases that have been just shielded, currently the 5601 marijuana possession, where it was the only thing going on in the case, the only charge. So those are now out of case search. Are just those able to be, and I'm going to stop using the term automatic expungement, but are those able to be handled as a group without the person in question having to apply? Like, at least for those isolated charges, can we handle those through something that doesn't require an application?
That's what we did with one of the bills, is that there's no application. We blocked it from case search. So now you'd see if there was, let's say counts 1 and 2 you were convicted of, but counts 3, 4, and 5 were entered nolle prosequi, which is not an unusual situation in court. In fact, it's rare that all of the counts are ever a conviction. It's usually either by plea or at trial. Some of them drop out. Right now, if you searched on case search for that, we would show counts 1 and 2 because they're convictions that otherwise under your expungement rules can't otherwise be expunged. But 3, 4, and 5 would show charge removed, and that's what you would see when you went into case search. So you wouldn't see those anymore. And if you went to the courthouse, you could. There's an unintended side effect of this is that individuals that were doing the expungement clinics are having a hard time because they can no longer find some of these cases on case search anymore, or they only find a partial case, but they always have the ability to come into the courthouse. They just can't sit from wherever they're doing it, either automatically or through a screen, scraping device or whatever that may be.
But if it's by itself, and we've now removed it from case search, are we, if we include in some future marijuana legalization law to just fully expunge those and remove that ambiguity, is it possible, at least with just those single charge cases, to do a full expungement?
I hate to intervene in a question, but and he just said yes, but let me just clarify on the question, Delegate Moon. When you say by themselves. What do you mean by that?
It was the only charge in the case.
Oh, okay. I'm sorry.
Marijuana possession.
Got
It's
it.
not a unit rule problem.
Right.
It's just a single, I think we have thousands of these. Right
Got it.
now we shield them, but I guess the question is, if we legalize, are we now able to just fully expunge just those records?
So if I could
Yes.
just add to that,
Go ahead,
yes, as Judge Morrissey said, yes. But there are an extraordinary number of these cases. So it should be clear that it would take a lot of time to do that it wouldn't be something that could be accomplished in a matter of days or weeks. It would take quite a while.
All right, I have one question. It might be the only other question, and it goes to a point that you made, Your Honor, in your remarks with reference to possession with intent to distribute. The way that that's charged, it's generally charged as possession with intent to distribute, and it doesn't identify what is being distributed, whether it's marijuana or anything else. So you went through the process pretty clearly. What would a process look like, I guess, to deal with that particular crime when you're looking at potential expungement? And then I see Delegate Williams, and then we're going to let him move on.
I'm not sure I can answer that. It can be by specific CJIS code if you want to try to define it by that level. Rose, I'd kind of defer to you if you have any thoughts. That's a difficulty
Sure.
that we're having.
So with something like that, we would have to identify the cases through the CJIS code, and of course pull a list of them. With the number of years of documents that we have to be able to go back and look at the narrative to determine whether or not marijuana was involved in that case or not. Now,
So with all the PWIDs, with all the possession with intent to distribute or PWIDs, you'd have to go back and look through each and every single one of those cases to determine
correct.
what the substance.
That's correct.
There's
And
not a technological fix there.
So the only technological fix that would really be out there is massive scanning of those documents into a computer system, whether that's MDEC or something else, and using AI software to determine that. But as Judge Morrissey has said, AI software, we've done a lot of research on that, and it's just not, it's not an answer to everything. It would certainly be able to identify a lot, but depending on whether we're dealing with a written statement of charges, and certainly 80s and 90s cases, we would be dealing with a tremendous amount of written charges. And handwriting is difficult in AI. And then the second piece to that is, how was the information written in the statement of charges? Is it green leafy matter? Is it, a green leafy substance? Those, differences make a tremendous impact on whether or not AI can be successfully used. So it's not an answer to everything, but it may provide some options for speeding the process slightly, but it is not a full service solution by any stretch of the imagination.
I'll just say very quickly before giving it to Delegate Williams here, my question is genuinely not meant to say that we absolutely can't do that. I think that we just need to recognize that there is a technological and a practical issue on that specific charge. But that specific charge, possession with intent to distribute, is, I think, really at the crux of the important charge that we need to look at as we go through the process of doing expungements. With that, Delegate Williams.
Yeah, my question was just piggybacking. Thank you, Mr. Chair. Piggybacking on your comment, Ms. Day, about kind of the time frame. So it sounds like you guys have kind of thought about this a little bit, and I know can not happen overnight or even a week, but what is your sense about what that time frame would look like if we were to go down this road?
I'll defer to Rose, but I can tell you that you're talking about millions of case records. We've estimated in previous fiscal notes of needing several hundred additional clerks in order to do it in a several year period, but I'll defer to Rose on, she knows that better than I.
Right. It certainly would take several years. I mean, it's not something that is a quick process. We have looked at, and we haven't even delved into the possession with intent to distribute because we're not able to identify what that number of cases looks like in relation to marijuana. But as far as strictly marijuana cases where there is a marijuana charge, and I don't know the numbers off the top of my head, so I apologize, but it is an incredibly large number of cases that have been identified that go all the way back to, the early 80s, where we have some type of electronic records. It doesn't even go back further than that, where we would have to start going through manual paper records. And as Judge Morrissey said, the estimate just to get it done, and I believe it was about a 3-year time frame, would take several hundred additional employees to do that, along with what we're already currently doing. So huge undertaking to do that.
I just want to make one other comment about MDEC is that when we go live with MDEC, we convert the prior case management system over. But remember that was not in any of the jurisdictions we've gone into. They weren't electronically keeping documents in any of these case management systems. We don't scan every file in that's ever existed. We only scan in what's existing on the day that we go live, and then we'll scan on demand if someone reopens a case or something happens after the go live date where a case is entirely in paper and then it becomes active again. We'll scan that case in. But for us to go back and try to scan in, decades worth of cases would be impossible for us to do. And that decision was an easy decision made early on in the MDEC concept that we wouldn't be able to do something like that, nor were we going to do that. So, our electronic documents start in 2014. Anything prior to that would have to be scanned into the system if we were, or some system. It may not be MDEC, it may be some other system, but it would have to be scanned into a system, and that type of batch scanning can take a considerable period of time.
I promised to let you go, but Delegate Wilson has a very, very brief and succinct question.
Thank you, Mr. Chair. It is very brief because I just want to make sure that we can find a process to put in place for the individuals that actually need their expungements immediately. I understand the broad stroke that we're trying to do. Some of it, and very much of it, may be very pointless. You go back 14 years, these people may not actually care, but there are individuals right now or from 5 years ago. And is there a process, a request form, or something we could do to expedite those and get those to the head of the line, lest we have these millions and millions of files that have to be replaced, systemically? And if you don't have an answer to that, that's fine. It's just something I'd like you to keep in mind, is a way for individuals who currently really want this done, need it done for their employment or whatever, that they can jump to the front of the line before we continue to do this, again, broad stroke where we expunge everybody's. And I just don't want to miss those individuals because we're trying to do right by cases that are 20 years old. That's more of a comment, Mr. Chair. Thank you.
All right, thank you all very much. I think we didn't keep them too long. We thank you very much to Chief Judge, Ms. Day, and we will let you go.
Thank you, Chairman and members of the committee. And as always, we look forward to working with you.
All right, let's move now to the second part of our presentation, when we're going to hear from panelists from the Department of Public Safety and Correctional Services. We'll hear from the department's Chief Information Officer, Stanley Lofton, and the Secretary's Chief of Staff, Rachel Sessa, who are going to talk about CJIS, the Criminal Justice Information System, and the impacts associated with the potential legalization of cannabis. And I see Ms. Sessa and I see Mr. Lofton. Whoever would like to begin, go right ahead.
Wonderful. Well, good morning, Mr. Chairman, members of the work group. For the record, my name is Rachel Sessa. I'm the Chief of Staff of the Department of Public Safety and Correctional Services. And with us here today virtually is the department's Chief Information Officer, Stanley Lofton. He oversees the department's information, technology, and communication divisions and is here for any technical questions. Among other things, the division houses the Criminal Justice Information System, which we refer to as CJIS, The judiciary's presentation was extremely comprehensive and covered most of the material we would present, but we greatly appreciate you allowing us to be here today. CJIS is responsible for overseeing the state's computerized central repository system and also plays an integral role in conducting expungements. The central repository system maintains Maryland's criminal identification records and criminal record information, a lot of which is linked to biometrics and fingerprinting. As I'm sure you know, criminal history record information is data that's developed or collected by a criminal justice unit about a person, and that pertains to a specific reportable events. And there are actually 25 reportable events that are stipulated and listed in Crim Pro Article Section 10-215. Those include events such as arrest, conviction, incarceration, again associated with that resulting fingerprint and biometric that links back to the criminal history record information. As the Chief Judge said, unlike judiciary case search, the central repository system is not a database that can be accessed by any member of the public. The criminal history record information maintained in the system is used by criminal justice agencies for things like investigations, apprehension, prosecution. We use it for correctional and supervision classification and some other criminal justice purposes. As I'm sure you know, criminal history record information is also used in generating background checks. So entities that are statutorily authorized to receive a background check on an individual include a lot of state and government entities like the Department of Education, their Office of Child Care, the Department of Labor, Department of Transportation, the Maryland Racing Commission, and the Maryland Medical Cannabis Commission. There are also certain specific non-government entities that also have access to and can request a background check on an individual. Chief Judge Morrissey also did a great job in explaining the distinction between an expungement and shielding. And so just wanted to kind of explain on our end what occurs whenever an individual petitions for and successfully receives an order for expungement of a record. So the CJIS receives that court-ordered record and includes a tracking number and a certain identification information. Then the CJIS staff actually search the central repository, and it's linked back to that CJIS code, which is generated by JIS. And then they review to determine, whether the record exists. If there is no record, we then notify the court, the arresting agency, and petitioner just to say, hey, we don't have a record of this. If there is that record and it does exist, then staff update the system to remove the data so it can no longer be seen by entities authorized to view criminal history record information. The system then sends electronic messages to the other systems that may have a similar record to remove fingerprints, mugshots, or any information within the sex offender registry pertinent to that record. And I know that then the Chief Judge Morrissey covered very well about the change as it relates to automatic expungement, and for certain offenses, no longer the need to generate a compliance letter to the court, but for many others, that is still part of the process. And once we have completed it on our end, CJIS's end, we generate a letter of compliance to the court, the arresting agency, and petitioner, indicating that record has been removed from the system. And as the presentation alluded to, there are a number of other criminal justice entities and a few within our agency that also has a parallel process in the expungement process. Our Division of Parole and Probation and our Division of Correction, if they receive the expungement order, they also have to review the offender case management system and various other systems to make sure that record is removed from those as well. So there is quite a bit of manual process involved in expungement. And it's even further complicated the farther back that you go, as the judiciary alluded to, in that I think prior to approximately 2004, and that's as far back as we can go and recall, is that prior to that there were no specific JIS or CJIS codes associated. And so any expungement prior to that date involves quite a bit of additional searching and vetting. As it relates to automatic expungements and partial expungements, I'll start kind of with automatic and then move on to partial. Automatic, as you heard, it really only applies for the need for an individual to file an application or petition for expungement. CJIS still would need to be notified that the person, those convictions need to be expunged. So there is no push of the button. It still requires that kind of manual search on our end. And with regard to partial expungement, the unit rule, and I think Delegate Moon already alluded to, obviously a lot of subject matter experts here, the unit rule comes into play. So where charges or convictions come through on the criminal history record information as one unit linked to a primary charge, which is why they're kind of listed out numerically. So all of the records on the same unit must be eligible for expungement. The partial expungement process would be time consuming and very staff intensive. Of course, we follow the statute and any changes prompted by the legislature. For routine expungements, CJIS receives the tracking and case number for the record to be expunged. However, there are instances where this information may be missing, requiring follow up with the court or arresting agency to try and get some additional information. For partial expungement, we would need even more data than just the tracking and case number. We anticipate that we would need the date of arrest, the specific charge, the state identification number, and even perhaps some more identification information in order to discern which of the charges or convictions within the unit need to be expunged to make sure we're getting it right. And it would also cause we would need to do some software upgrades. But once we have that information, the person doing the partial expungement would have to manually inspect each of the records in each unit to accurately identify the charge that needs to be expunged. And since they are, again, reported in numerical order, even if one or two were to be expunged from the units, it's difficult to do the renumbering. And so you can still kind of see where additional charges or convictions were once on the record. That being said, we completely understand the important nature and discussions and focus of this work group, and we appreciate the opportunity to appear before you today. We're happy to answer any questions that you may have, and if we don't have those answers, we're more than happy to follow up as well.
Mr. Lofton, do you have anything?
Sherman, thank you for the question. No, I believe Rachel did a great job covering all the points that we wanted to share this morning.
All right, that's fine. There are questions. We'll begin with Delegate Wilson, then Delegate Moon. Delegate Wilson, please.
Thank you. Ma'am, I was just calling, again, I don't know if maybe I zoned out for a moment, but could you go back over, you were talking about shielding and removal of information from the sexual offender registry.
Sure, that's an excellent question. So it wouldn't be pertaining to shielding. Shielding is the removal of something from the judiciary's case search. I was referencing the expungement process and as it relates to the central repository system or criminal history record information. And in the event that someone successfully petitions for an expungement, it requires the review and removal of information not just from the central repository, but from other criminal systems by the agency, and it could include the sex offender registry as well, just depending upon what the order of expungement dictates that we remove.
Okay, so you were just talking in general. You weren't talking specifically about anything to do with the cannabis. I just want to make sure we weren't jumping into some situation that we didn't need to be into. So never mind. Doesn't sound like that applies to what we're talking about today. Thank you.
Delegate Moon.
Thank you, Mr. Chair, and thanks for the information. I just want to, I guess, I feel like, for folks who haven't been following the expungement policy developments, this might be a lot of information. And so I'd like to focus on what's possible to do more quickly as opposed to sort of, what's difficult to do, because that part seems like fairly daunting. And so just so I understand, folks understand, the expungement that the judges were talking about, full-blown record expungement, like let's go and find anyone who has copies, traces, and touches this record, paper, electronic, and get rid of that. I've been trying to get us to a more manageable place as we get to showtime here. And so it's seeming sensible, and stop me if I'm wrong with anything here. You mentioned some date and time at which it was more easy to find records based on how the crimes were coded. So things like that, electronic records versus the paper records, there's obviously a date and time we can cut where we're looking at the electronic records either first or only. So same question, if we're dealing just with possession of marijuana for which there are electronic records and for the date at which it wasn't lumped in with other drugs, for just those charges, am I correct that we can more easily get them just out of CJIS? And the judges are apparently saying we're already doing that on the case search side. And that if we do that, CJIS and case search, we're handling most of the background check sources, right? And the public facing court website. Is that feasible to do without all of the complications you've noted? Just the possession of marijuana charges for which there are electronic records, we search it by CJIS and get them out of CJIS. And sort of the process of contacting everyone else, every other agency, that might take 3 years. But am I right that just handling the marijuana possession in CJIS might not take 3 years?
Delegate, that's an excellent question. And just to kind of give a little bit additional information about typically the volume that CJIS is receiving, and I'll be sure to come back and circle your questions about what is easiest, what may be the low-hanging fruit here. But just to kind of give some context about the number of expungements that CJIS receives and the volume that is handled, it's actually increased well over 10% over the past 3 or 4 years alone. In 2017, they received 48,848 court orders for expungement, so nearly 50,000. In 2018, nearly 70,000. 2019, nearly 73,000. And 2020, well over 50,000. And that was, we think it dipped a little bit because of obviously the issues with the COVID-19 pandemic and access there. So in consideration of the volume for the expungements that CJIS is handling, it is notable and it is significant. But in terms of what is things that are more simplistic or certainly easier, and CIO Lofton is probably going to say, well, easier it just depends upon the context, but I would say that anything that is within that one unit, right, that it's the only charge within that one record, that is certainly far easier to do currently. And in terms of, we certainly follow the order that we received from the courts in terms of, what prioritization. I wouldn't be able to comment on that if that is something that is feasible in terms of prioritizing certain orders of expungement over the other. But in terms of, what is the easier kind of route is the assuming that that was the one charge in the entire unit, if that makes sense, Delegate. And CIO Lofton, did I miss anything there?
Thank you, Rachel. No, you captured it. I mean, the order is still the same body of work, if you will, because we'll get the order and we still need to determine whether or not that case only has one charge. So we still have to go through and do that analysis. And if we find that there's one charge, one case, that's what we call a cancel entire, and we would eliminate the entire, that would be the unit.
Okay. Are there further questions for this panel? Seeing none, we thank you all very much. And since we appear to be on schedule, see how long that lasts. We'll hear from Michael Hartman now, our third group. Michael Hartman, a research analyst who works in the area of criminal justice reform at NCSL, the National Conference of State Legislators. He's going to provide a global overview of the criminal justice impacts as seen across the nation as other states have legalized cannabis. And I believe there are others on board here from NCSL as well. There is a PowerPoint and it's on the screen. So why don't we go ahead and get started? Mr. Hartman, please.
Well, hello and good morning, Chairman Clippinger and committee members. Thanks for having me speak today. My name is Michael Hartman, and I am a policy associate in NCSL, as mentioned. I want to be conscious of your time, so I am going to try to keep my presentation quick, giving as much possible time for questions. It seems like you guys have really dug into this issue itself. I will be covering a lot of loosely fitting topics within CJ impacts. So if you have more specific questions about any of them, just please let me know. If I can't answer it here on the spot, I can always follow up with you after the presentation with a more thorough response. So without further ado, let's go ahead and begin. And can I get next slide? Thank you. Today, I will talk to you about two main topics within criminal justice impacts, which I've broken down for you on the slide here. First, we will look at some system impacts to consider, including continued decriminalization for unlawful use, record clearing, and court supervision of those lawfully using cannabis under state laws. Next, we will discuss a handful of recent reports that have attempted to look at larger societal impacts following legalization, of course, through that criminal justice lens. And then, as you can see, these come from a wide variety of states and even outside organizations such as the Cato Institute. So with that said, let's jump right into decriminalization of cannabis. And we can go to the next slide. So in addition to the Virgin Islands, 28 states and DC have alternatives to incarceration for cannabis possessions. I know you're considering legalization, so what does decriminalization have to do with it? Well, I just like to highlight decriminalization to make one main point. And just because cannabis is legal to use recreationally doesn't mean every joint smoked is going to be legal. Especially considering many recreational states only allow those 21 and up to legally consume cannabis. Just like we had underage drinking as a crime, underage cannabis will remain a crime. As such, legislators are still considering decriminalization for those populations most likely to still be in violation of legal cannabis use following legalization. For example, Delaware recently decriminalized possession and use of a personal quantity of cannabis for juveniles, bringing their juvenile code in line with their adult code, which decriminalized back in 2015. Similarly, New Jersey tackled this issue by reducing juveniles and the 18 to 20-year-old population's use from a petty disorderly persons offense to a civil penalty with reduced potential fines. There is a lot that goes into decriminalization, but I just wanted to primarily highlight that the issue does not simply go away following legalization and should still be reviewed from time to time. And in fact, it can actually be a way to handle the record clearing issues that you were talking about. I will just highlight the Virgin Islands decriminalization statute has provisions within that statute that prohibit records being made for those civil offenses. Just as a refresher, Maryland's decriminalization did happen in 2014 and applies to less than 10 grams, as I believe the judge mentioned earlier. It is a civil offense with a $100 fine for the first offense. I would say this falls within the average range for decriminalization, but I'd like to quickly go through an example policy pendulum for decriminalization to give everyone kind of a better understanding of where Maryland falls amongst the states who have recently passed decriminalization. So we can go to the next slide. And as you can see, I've picked 3 recent enactments from North Dakota, Virginia, and then most recently, Louisiana. First off, North Dakota, a state which has a medical cannabis program, passed cannabis decriminalization back in 2019. I would say this was a mild approach. Not only does it continue to criminalize use by those 20 and below, but provides that even 21 and above may be charged with a Class B misdemeanor if it's their third infraction within a single year. Additionally, the $1,000 fine is atypically high when compared to many jurisdictions. But regarding the half-ounce limit, this is not entirely uncommon, but most states do set a limit at 1 ounce or even higher. As mentioned, Maryland has it at 10 grams at the moment. Next to discuss is Virginia, who does follow the more common 1 ounce limit. Subsequently to decriminalizing, Virginia has also legalized cannabis for adult use. But we are going to focus just on that decriminalized unlawful use. So in addition to Virginia's incredibly low, only $25 fine, their law attempts to address that possession with intent to distribute cases as well by creating a rebuttable presumption Although this doesn't really change any of the elements of the crime, it does make intent to distribute slightly more difficult to prove in court, as you now have an additional evidentiary hurdle to get over for those arrested with 1 ounce or less. And then finally, Louisiana, like North Dakota with a medicinal cannabis program, falls somewhere between North Dakota and Virginia. As you can see, Louisiana uses the amount of 14 grams like North Dakota. However, its fine of $100 is much lower and closer to what could be considered the common fine amount, like Maryland's. Additionally, Louisiana law provides explicit instructions for judges to consider alternatives to paying the fine if it is determined that the individual is indigent and unable, but still willing to pay the fine. And one last unique point to mention is that Louisiana law provides a summon in lieu of custodial arrest. Due to the way Louisiana crime classifications work, this provision allows Louisiana to effectively turn their offense into a civil infraction, like most states. So with that said, let's jump into record clearing, as it is the primary discussion of today. So we can go to the next slide. Record clearing is the broad terminology I like to encompass the variety of laws directed at eliminating collateral consequences that stem from criminal records, such as difficulty in finding housing and employment, and even higher education opportunities. The map on your screen briefly shows the states that currently have record clearing laws that are specific to cannabis, decriminalized offenses, or legalized offenses. So that makes for a total of 24 states and Washington, D.C. that do currently have such laws. You can see that those states on the slide now, as you can see, Maryland is included on that list. I will say that I do prefer to separate these out from general record clearing, primarily because of their specific nature. However, that does not mean they're all alike. For example, some are very broad and cover all offenses which have subsequently been decriminalized or legalized, while others only apply to very specific cannabis offenses in their criminal code. The reason I point out this distinction is because the recent trend to decriminalize or legalize other controlled substances. For example, Oregon recently passed ballot measure 110, which decriminalized personal non-commercial possession of any controlled substance as no more than a Class E violation with a maximum of a $100 fine. Oregon did choose to create cannabis-specific record clearing. However, had it chosen, like many other states have, to provide record clearing for all decriminalized offenses, those record clearing laws would extend to any other decriminalized controlled substance. Maryland, Vermont, and Rhode Island are just a few examples of jurisdictions who do have laws to provide record clearing more broadly to include all offenses, either decriminalized or legalized. I believe in Maryland, the term it is for legalized offenses. But now let's very quickly turn to how jurisdictions are defining record clearing and what the difference between automatic and petition-based record clearing, which you've already heard a lot about, but I'll go into a little bit more detail. Next slide. So I know we've heard a lot about terminology today, but I'd also like to start with terminology and what record clearing really means. As you can see on the top left of the slide, I've given the Black's Law's dictionary definition for many of the terms used in record clearing. Unfortunately, most jurisdictions mix and match terminology and meanings regularly. So as there is really no uniform definition for many of these terms when looking at the law, each state is unique in that way. So with that said, I describe most record clearing laws as sealing laws or shielding laws, which the judge discussed earlier. Although perhaps not the preferred option for those currently with a record, sealing as opposed to destroying does give jurisdictions slightly more control over what the records might be used for in the future, such as during subsequent criminal offenses, for jury duty eligibility, or even to continue certain collateral consequence restrictions, such as those placed on voting or obtaining concealed carry licensure. In previous generations, where actual storage space was a limit, keeping all of these records could have become a logistical nightmare. However, with modern file storage technology, there's virtually no logistical limit to the amount of information which can be kept in government records or shielded or sealed in government records. And then with regard to automatic versus petition systems, states also vary widely. I've given general definitions on the slide, but one key difference is that on petition record clearing provides that forum for objectors, which the judge mentioned when he was walking you through those steps. Whereas automatic and automated record clearing is streamlined for efficiency and doesn't always allow for that objection. So recently, some states have made efforts to streamline even their petition processes. For example, Colorado requires the court to grant a motion to seal records without an opportunity for the district attorney to object if the person has not been convicted of a criminal offense since the final disposition or released from supervision, whichever is later. Along those same lines, Utah recently eliminated the requirement for a certificate of eligibility, which streamlined their petition process substantially. And I know you've been talking today about automatic and petition and how both of those are at use. Well, you're not alone. A lot of jurisdictions have pursued both options to help with cannabis record clearing legalization. For example, Connecticut, who recently legalized just in 2021, simultaneously included record clearing provisions for both automatic and petition. Connecticut set up a petition-based system for a wide range of possession and use offenses, as well as a variety of lower-level felonies. Additionally, is implementing an automatic record clearing system for certain possession offenses only, which I believe fall into a particular timeline, kind of like how you guys have been discussing those lower-hanging fruits. A big reason states are trying to switch appropriate offenses to automatic record clearing is because studies have shown that many eligible individuals never end up filing a petition due to a plethora of reasons I won't get into today. But with that said, it's worth noting that the cost to create automatic or automated record clearing is still rather steep upfront. According to recent research surrounding Pennsylvania's enactment of automated record clearing, now this was a general system, not a cannabis specific one, fully automated systems cost approximately $2.96 per person after an initial $3.4 million to set up. And that is for an estimated relief population of about 1.15 million. So just over a million records. That can be compared to what is currently $3,757 per person for the legal clinic assisted petition-based record clearance. And then, as you know, without clinic assistance, that petition cost can go up even more. As you can see, the upfront cost to automating the system can be incredibly expensive, several $1 million, but the ongoing costs following implementation are incredibly marginal in comparison with traditional petition costs per person. Additionally, though, these costs are then typically shifted from those seeking the record clearing to either state or local government to implement and kind of provide that funding for the startup of the software. And then finally, I do want to briefly touch on how courts have been responding to supervisees who use cannabis following local laws, of course. So next slide. So I'll essentially say courts have three main approaches when handling participants using cannabis. Those are on your screen now, but I'll go into a little bit more detail for each. First, the abstinence-based approach would generally include court rules that state something along the lines of do not use or possess any drugs or alcohol and do not even think about applying for a medical cannabis card. These courts will generally respond to any drug use, including cannabis, with corrective actions such as verbal warnings, increased court visits, stricter drug testing, delays in program graduation, brief detention, and even being kicked out of the program entirely. Second, and on the opposite end of this policy spectrum, we have tolerance-based approaches. So these courts would typically have a rule that states something like, this court does not encourage cannabis use given its health risk and illegal status under federal law. However, we do not take punitive action against participants in our court for using cannabis use. And then finally, somewhere in the middle are the adaptive approach courts, which tend to state something like, as a participant in drug court, you are agreeing to not use alcohol, illegal drugs, or unauthorized medication. This includes medical cannabis unless authorized by the court. So this approach kind of has that abstinence as the status quo, but grants the court discretion to allow cannabis use when they deem it's not harmful to the individual. Unfortunately, where we stand now, there really isn't enough data to determine which of these approaches is quote unquote the best approach. But it's really important for policymakers to still consider, nevertheless, when thinking about public safety and cannabis legalization. Finally, I wanted to discuss public impacts from legalization, specifically focusing on some of the challenges data analysts and policy analysts like myself are facing when trying to determine the full kind of impact legalization has had. So next slide. So I will start by taking you through 5 or so studies which looked at impacts following cannabis legalizations. I do want to state at the beginning that many of these efforts admit that some of the information being sought, whether that's how much increased drug use there is in meth or heroin, increase in other specific crimes, is not really easy to ascertain. And I've been reading a lot of 2 main reasons for that. First, a lot of this data needed to make such assessments is not currently being tracked. I believe several of the speakers today kind of mentioned the way that the tracking system doesn't perfectly align with the type of record clearing we're potentially pursuing. And second, of the information that is tracked, it is not always in a unified or systemic manner. I believe the judge kind of walked you through that history timeline for Maryland, at least, as they started moving towards that electronic system and then a unified or single electronic system storage. So it's really difficult to kind of compare apples to oranges if you don't have those uniform systems. So what this really means is that it's kind of hard to determine the exact impacts legalization has had on particular public safety issues. But with that disclaimer aside, let's start with the Cato Institute's report. So they somewhat recently did a 2021 update to their study covering the effect of state marijuana legalization. Their research attempts to compare state data against national averages to determine cannabis legalization effects. Although not perfect comparison, due to the other variables at play, this does give some level of credibility to its conclusions. So with that said, the Cato Institute concluded that overall, violent crime has neither soared nor plummeted in the wake of marijuana legalization. And in fact, their work shows that most states track the US national trends, while violent crime in Maine and Nevada did decrease, and crime rates in Alaska and Massachusetts did slightly increase. Next, let's take a look at California. California has been dealing with a black market problem in their states, although it's difficult to assess what size the black market is. The California 2019 annual report stated that throughout 2018 and into 2019, the illicit black market flourished due in part to the need for more enforcement and limited enforcement tools, coupled with the competitive financial advantages illicit operators have over legal cannabis businesses. Obviously, legal cannabis businesses are required to pay local permitting fees, state licensing fees, and local and state cannabis taxes. Other reports from California do discuss the impact of cannabis taxes specifically on the illegal market, but they don't really make an attempt to estimate the size of that illegal market. At the moment, people can really only guess as to how much cannabis is actually traveling through black market means in California. So next, I'll talk a little bit about my state that I'm in now, Colorado, who also publishes annual reports on marijuana impacts, and they have this in their legalization efforts as a statutory mandate. So unfortunately, these reports are not as helpful as one might think either. Although they do provide some really good information, they are full of explanations why there really isn't enough information to come by any real conclusions. For example, when trying to compare pre-legalization and post-legalization arrest rates, the arrest data being kept only dates back to 2012, kind of that we only have electronic records dating so far back issue, which, if you don't know, is also the year Colorado passed recreational use. So it doesn't really provide them a great control to compare with. This is sort of why the Cato Institute attempted to compare with national averages, is trying to look at time periods in which we do have the data and it is comparable. Although moving on, we'll look at Massachusetts quickly. So the Massachusetts Cannabis Control Commission released a report which discusses an industry-backed estimate on illicit marijuana sales in the state. According to their report, they estimate 76.3% of marijuana sales are through the illicit marketplace. With such a pinpoint percentage, you might ask, how did they come up with this estimate? Unfortunately, the report utilizes proprietary methods to determine their estimates, so we may never figure it out. They did work in partnership with a private industry in order to come up with those estimates. And finally, I just want to mention a study done by the RAND Corporation regarding legalization in Washington. The report admits, as I've been stressing over and over again, that calculating the total amount of cannabis attained by residents via illegal sources is really difficult with existing data sources. However, it does conclude by using additional data from National Survey on Drug Use and Health and a survey of cannabis users in Washington. The authors calculations suggested that in the third year after implementing a regulatory system for cannabis, between 40% and 60% of cannabis obtained by state residents was likely purchased in state licensed stores, i.e. purchased legally. So I really do wish there was some magic studies which could give us some real answers as to how cannabis legalization affects the criminal justice world more broadly. However, there really is no good analysis out there, in my opinion. It's a difficult thing to track with the opportunity for so many other variables to kind of come into play. For example, the world-altering events like the COVID pandemic plays a large role in things like public safety and national crime rates. And it's something that's not really easily eliminated from the data as a variable in many of these studies. And so with that, we can go to my final slide. And I'd like to say, thank you for having me speak. I'm sorry I was a quick speaker and may have covered a lot of topics, but I am more than happy to answer any questions anyone has now, and we can get into a little more details if we need to.
All right, that's fine. I think we're also joined by Carmen Hansen from NCSL. She's here too, just putting her on alert. There may be questions heading your way as well. We'll start now with delegates Wilson, then delegate Lutke for questions. Delegate Wilson.
Thank you, Mr. Chair. Just a few questions. One of the things I was a little surprised to hear when we were talking about minimizing penalties for the marijuana usage in juveniles. I believe that's one of the Marylanders' biggest issues. It is a clear-cut science now that marijuana has negative pejorative effects on individuals under the age of 25 in the developing brain. In addition, it's also very much it's knowledge, public knowledge that any juvenile offenses are pretty much sealed once they become adults. So please explain to me, if you can, what the policy / logic is behind dropping the bar, lowering the penalties for juveniles who we actually, I would understand or believe, do not want them to use marijuana.
Yeah, so I guess what we're really looking at is two issues. In the complete juvenile world, as you mentioned, they do go, most states have juvenile record clearing laws or sealing laws, so that record wouldn't follow them around. In most of those decriminalization laws, I guess the intention is really to divert them from the criminal justice system as opposed to not punish them. So many of those actually, specifically the juvenile ones, have clauses that require them to take then drug awareness classes or drug education classes or things like that. So that is the intent there. And then the other kind of population, that 18 to 20-year-old, which, as you mentioned, still falls into that developing brain category up through 25. That is that other category that they're trying to look at, because they would still go through the adult system. So if in states that don't have decriminalization, potentially that record could follow them for a long time. And again, a lot of the intention is that we're trying to divert them from the criminal justice system and into other resources. So whether that's treatment resources, drug courts, diversion courts, or other options like that, that's really what it's trying to get at there.
And I understand the 18 to 25. I'm all about understanding how decriminalization, not having this record follow you. I just think we're ignoring a huge issue in our culture if we're with the juveniles and their consumption of marijuana. You also brought up something about the absence approach to court supervision, and I was paying attention, but courts often mandate that you have no alcohol or tobacco, or alcohol, or any substances that will alter your mental state. So I don't believe it's a stretch for them to continue that. And I don't know, again, it's one thing, I guess, if you have a sickness that requires you have marijuana, it's like a prescription, but we're talking about now recreational use, and I don't see the courts deviating from that. One thing you didn't cover, I would love to hear a little bit more about, is the impact on marijuana use as far as DUIs, driving while under the influence, and how these states are affected by that, how they're following that, how they're trying to keep up, because we have a lot of active organizations in Maryland, Mothers Against Drug Driving, all that. And, we have some of the toughest laws in the country right now, which I believe is in juxtaposition to what we're now trying to do as far as allow people access to marijuana. And when I believe the states have not been able to get that DRE thing lined up for drug recognition experts, knowing if somebody's currently high while they're driving. If you don't have any input on that, I would love to hear some later. If you do, I'd love to hear it now.
So I didn't talk about this in the presentation, but it's a very good point you brought up. And traffic infractions and driving while intoxicated or driving under the influence is a huge thing. We actually do track DUID laws for cannabis use. We could get those out to you. I could definitely forward those over to you so you could look at them and what states are kind of doing. I will say, regarding driving while intoxicated usage, I've seen anecdotal studies on both sides of that issue. So it is a tough one, and states should definitely be looking at it, as well as trying to figure out how you do enforce. So even if you make those laws, like you said, how do you actually enforce drivers? How do you recognize that someone is intoxicated versus not intoxicated? Cannabis becomes a very complicated issue there. We do have some resources on that, so I'd be glad to reach out to you afterwards and send them over to you.
I believe the entire committee, the entire work group, it would benefit us, because that is one of the big hurdles when we're moving forward, is how to deal with keeping our roads safe. And contrary to a lot of my friends that do it, you don't drive better when you're high. It's just a rumor. And want to make sure that we don't have these individuals on the road, that we also realize how we can, recognize these individuals and what we can do, because this also goes into another issue. The chairman and myself were talking, which is currently right now, if a cop pulls you over and they smell alcohol in your car, they can look in your car. And the same, I don't think, was going to change if we legalize marijuana. Even if marijuana is legal, much like alcohol is, you still can't drive and drink, and you still can't drive and smoke. So it's not going to be the saving grace that people think it is, just because it becomes recreational. And lastly, when you were discussing illegal sales, one of the things I would like to get, since I know you're talking about, you're doing percentages of how many people get what, legal versus illegal. I would like to just see the numbers of PWID arrests and convictions from the states like California. Like, meaning how many people are being now still arrested for possession with the intent to distribute marijuana? Because I think that would help you give an understanding of what we're talking about. Number one, what their standards are for PWID, and also how many people are still participating in that black market system. Has it gone up? Has it gone down? I've heard both ways, Colorado and California, two distinguishing examples of the marijuana usage and creating more of a black market, because you're creating hunger, but because it's so expensive, individuals are ready to go on the black market and get skunk weed than something specific to purple haze or whatever. So if you could get those numbers, I think that would be great, because that does help us get an understanding possibly that, well, that black market doesn't go away just because it becomes legal, but even helping us understand, do we actually populate that black market depending on the way we legalize this? I'll be very interested in that information if you can get it.
Yeah, so I've actually got all of these studies saved, and I can send this over to you. Some of these do go into some of those datas. Like I said, where they really struggle is trying to make that final conclusion of this was caused by, X was caused by Y. That's where they really struggle. But they do give you a lot of data points, especially when you're referring, some of them do track a lot of those arrests for the different cannabis offenses.
Yeah.
So you can see those rates. And again, like Colorado does a great attempt at trying to compare that with pre-legalization, post-legalization, to try to come up with an answer. But just the way that their records date back only to a certain point really hinders their analysis, I guess.
And definitely, I don't need a scientific conclusion. I think the group can draw their own conclusions from the data. So I would really appreciate that. Thank you for your presentation, sir.
I'm going to step in front of Delegate Lukey here for a minute because my question connects. Don't be upset, Delegate Lukey. I'm stepping in front just to tail on to the questions from Delegate Wilson. And I don't know, I would also be interested to see if there is a law review article or anything that talks about the case law involved with searches related to marijuana after legalization has occurred. Here in Maryland, we have a very active bit of case law right now that's coming out of the Court of Appeals, where we've basically said, okay, if an officer smells it in the car, then they can go and search in the car because it's treated as contraband. You can't have it in the car, so I can search a car. If I walk up to a person and they smell of marijuana, I can't search them solely based on the smell of marijuana. We are steadily, the jurisprudence is kind of moving as we have been moving on this issue. And I think it's an important question for us to address as we go to the issue that Delegate Wilson was addressing of people using marijuana or cannabis in the car. What scope do police officers have to search in vehicles when they smell the odor of marijuana or, in their professional judgment, a green leafy substance?
So as you said, I think that's a fantastic question because it's bringing in those Fourth Amendment issues of search and seizure. What I can say as someone who tracks the legislation closely is that legislators have not really been dictating this issue so much as courts have. Like you said, the courts are kind of determining how they do it. It would be, I am not aware of a law review article that covers just cannabis Fourth Amendment searches, but it would be fascinating if there was one out there. I can definitely do a search. And if one does happen to turn up, I'll make sure to include that in any information I send over to you.
Okay. I appreciate that. Now we will go to the less disappointed now, Delegate Lutke.
I'm very excited. Delegate Wilson helped me check my skunk weed bingo card box for the hearing. So, so here's Mr. Harmon. Here's my question. So you had mentioned these studies in a number of states, and actually this issue of the continued survival of the black market, I think, is going to be an important issue for us across criminal justice, business regulation, taxation, like the whole shebang. And I understand that the studies are not at the point where they can really identify causation in any thorough way. But is there a sort of discrete set of posited explanatory variables beyond? I mean, we hear about taxation, we hear about criminal penalties. Are there other issues we should be paying attention to in trying to from the black market to the legal market?
I guess those are the ones I would highlight: taxation, regulation. Essentially, I think part of the black market problem arises when regulations and taxations kind of eclipse what the consumer can afford or do, and then they turn back to their black market sources, and it kind of doesn't really. It doesn't really bring the industry to light, so to speak, because those operators are finding it easier to work in the black market. And then kind of along those lines is really, which I think this is what the California report sort of highlights, is part of the issue stems from, if you have a highly regulated market, a highly taxed market, you also need an incredibly efficient and well-run enforcement mechanism to make sure that people are abiding by that. Because as soon as you run into a situation where enforcement is sparse, only 10% of violations are having enforcement action brought, only 15%, then it really changes that dynamic of someone who's contemplating, do I go the legal regulated route, or do I just keep doing black market stuff? If my chance of enforcement is incredibly low, then I might choose the black market. Whereas if the chance of enforcement is raised, so if you really look at those enforcement mechanisms to make sure that your regulations are working, to make sure that people are complying, that does help. But again, I'll mention, a lot of these estimates to what that illegal market is are just that, estimates. Based
It's hard
off,
to measure. Hard to measure.
Very, very hard to measure who's doing illegal things. If we knew that they were doing illegal things, then maybe they wouldn't be doing that. So.
Right. Is geography a factor? I'm curious if that's been researched at all. I ask because, in Maryland, unlike California, where illegal grow operations were common, for decades, a lot of the cannabis consumed in Maryland is grown out of state and sort of imported to Maryland. Is that a factor, or is it, not really?
So, kind of on an anecdotal level, I'm not aware of any studies covering geography as a factor specifically, but I will say, just from kind of an overview, if you live in a state that is capable of growing outdoors in large quantities in vast areas, it's probably more likely to happen than if you live in a state that's maybe does not have the full growing season year round and has those harsher winters and would force people to, indoor growing might become more of a thing in a cold state versus a warm state. So geography does have a lot to play in regulations and all that stuff. But I haven't seen any studies specifically tying it to the illegal market.
Gotcha. Thank you very much. Thank you, Mr. Chairman.
All right. Are there any other questions for the panel? Ms. Hanson, would you like to say anything at all? You added something in the chat, but it's up to you.
Thank you, Mr. Chair. Yeah, I just wanted to say hello from NCSL, and we actually hosted one of the working groups here from Maryland in Denver in 2019 to do policy discussions and a tour of some of the local grow operations, cultivation facilities. We spoke with regulators here in Colorado. So some of the members, I believe Delegate Moon was there. I believe Delegate Pena-Melnick was there. It's hard to remember pre-COVID right now on exact dates, but we do have other information available. I kind of handle things from the health side. And we just had, we're actually still in the middle of the week here, hosting a delegation from the US Virgin Islands. So we just had 2 full days of presentations with them. And so I'm going to email Dylan and Aaron the handouts that we had on DUID for them. Unfortunately, CSL recently lost our expert on DUID, but we have her information as of September. So it's pretty straightforward slide presentation and some handouts to go with it. But if there's any other information, I can get things from law enforcement and our enforcement agencies here on what they're seeing on that illicit market still. But a lot of it is just kind of based on their experiences, and it's hard to really study it in depth. But they do their best because they want to measure that, on all honesty. They want to make sure they're being effective with enforcement. So if there's anything else we can help you with, we're happy to do so. We're always here. Next week, some of us will be in Tampa for a few days for our legislative summit, but we're always checking email. So please don't hesitate to reach out to us.
Delegate Moon for their question.
Thank you, Mr. Chair. And sorry, this is the end of the agenda. Am I correct? Yeah, okay. So I guess just generally then for our friends who are studying different states on this, have you seen anything showing any states either entertaining legalization or that have legalized that have gone more lenient on distribution or possession with intent? And I guess the reason I ask is it's beginning to sit funny with me, the idea that we would be minting millionaires, through the issuance of licenses. And our medical license system, it's a regulated monopoly, right? It's a 47 of this type of license, not that many licenses. So they're very valuable. And so I guess the prospect facing us is that we do this on the recreational side and we start issuing licenses to make people wealthy. And if the fewer the number of licenses, the fewer opportunities there are for people to legally participate in the market and make money. And so it seems a little disjointed to continue jailing people on the other end of this who operate outside of that market if it's very difficult to participate in the market. And so I guess the easier, and this goes along with the black market thing, but have you seen anything that's entertaining this philosophical conundrum in terms of criminal laws, and not just saying we're going to replicate jail as the penalty for participating in the black market?
California does. I know California has dropped their PUID of marijuana to 6 months. They've made it a misdemeanor, I believe. They've done a lot.
But it's still jail, right?
Well, correct. But just like selling liquor in Maryland is still jailable if you sell liquor without a license. There's still some standards. Otherwise, the FDA and health gets.
Well, that's what I'm asking. I mean, it's interesting. Like it's a felony in Maryland to bring unstamped cigarettes, or to divert the taxes, or to avoid the cigarette taxes. I don't know how much that's enforced, but I guess I would suggest that, given the spirit of sort of unraveling drug war stuff, I'm curious if anyone's done anything other than jail on this.
It's a good question. I'll say there is a lot of action in trying to differentiate, I guess, drug dealers from drug users, which isn't exactly what you're getting into, because you're saying, what is happening with the black market drug dealers, right? So what is happening there on a majority is actually their sentencing is typically going up, or they're making it more punitive in the attempt to say that, we really want to cut down on illegal black market sales. We have this legal route, please use it. But on the flip side, for those users, so that the smaller possession with intent to sell, those crimes are being looked at, and sometimes the weight amount is being raised. So you have to have more to be considered at sale. I believe I brought up Virginia had created a rebuttable presumption in their decriminalization to say that if it's less than an ounce, then, essentially there's a presumption that it's not for sale. So there is some action on that front, but I will say there's also states trying to make much higher level felonies for things like criminal organization, criminal enterprise, kind of running those large black market operations. Unfortunately, a lot of the arrests when enforcement comes in to a large grow like that does not take place on the person running the grow. It takes place on the person working the grow. But that is kind of the general overview, I would say, of the national landscape on that, at least.
Okay, are there further questions? Don't see any more, so we'll thank you both very much. Mr. Hartman, Ms. Hansen from NCSL. Thank you for your presentation today. Thank you for all of our guests for joining us today. We appreciate your time. Work group members have questions for any of our guests, further questions, you can email Dylan at dylan.goldberg@mlis.state.md.us, and he will connect you. The House Cannabis Legalization Work Group will continue to meet, and all of our future dates are posted on our work group page on the Maryland General Assembly's website. The materials from today's meeting will be posted on that page later today. We will meet again on Tuesday, November 9th at 1 o'clock regarding the topic of business regulation and implementation related to cannabis legalization. And we will provide more information about that meeting shortly from my office. Thank you all very much. We ended before noon. Who knew we